Good morning.
Good morning, Your Honor.
Good morning, Your Honor.
Good morning. Morning. All right. Do we have all the parties that we are supposed to have on our Zoom video conference for our 10 o'clock no evidence motion for summary judgment, or are we waiting on anybody else to join?
All parties for the movements are here, Your Honor.
All right. Let me go ahead and call this case then. I know we have our court reporter on. This is cause number DC 18-12287. May I have the parties just announce briefly? Let me know your names and who you represent in this matter.
Adrian Bauer for the movements, Paul Saputo and the Saputo Law Firm, PLLC.
Thank you.
Morgan Buffkin for the plaintiff, Andrevet.
Daryl Cook, Your Honor, for the plaintiff, Andrevet.
All right. Well, thank you. I'm Judge Monica Purdy. I don't know that I've met everyone on this Zoom video conference, so I'm the new presiding judge of the 95th District Court. So it's a pleasure to meet you all virtually. Look forward to the day where we can get back into the courtroom, but until then, this will have to suffice. So let me hear from the movement as it relates to their no evidence motion for summary judgment. I can tell you that I did take a look at the no evidence motion for summary judgment and the reply.
Okay, Your Honor. I think there is a response. So the motion, response, reply. Since then, I believe two other things have been filed. I'm not sure if the court's aware of that. The first being a supplemental pair of motions from the respondents. In the reply, the movements took issue with Exhibit A. It's a declaration from Mike Andrevet. There appeared to be something worth inquiring about on it. The non-movements have attempted to address that with their filing of Exhibits J and K, which are a replacement declaration. I'll be happy to let them talk about that in a bit. We still have issues with the replacement declaration, and so we've again filed something this morning, which should be in the
Your Honor, we were never served with the response, whatever he's talking about he filed this morning.
I think it came most recently.
The one it was this morning?
Yes, ma'am.
Hold on. Yeah, we didn't get service from anything from y'all this morning.
Okay, I mean, if the way filing works, it should work. If y'all want us to email a copy, I can have somebody from my office do that right now.
Okay. All right, I see. Okay, an email at 9:57 a.m.
Yes, ma'am.
Okay, supplemental objections. All right.
All right, and let me just say with respect to what counsel has informed the court about, the court wasn't aware of the supplements and the replies therefrom, but I will make sure to read all of that before I give you my order with respect to the motions that is before the court. So let's go ahead and hear argument at this time. The movement as it relates to their no evidence motion for summary judgment, the court will hear from them first.
Thank you, Your Honor. I represent the Saputo Law Firm, who was sued by Andrevet Legal, Media, and Marketing in this case. It's a small breach of contract sworn account quantum merit claim as per the original petition. I think the amount was less than $6,000. We're here in district court instead of small claims. That wasn't our decision. The Saputo Law Firm counterclaimed and alleged DTPA violations and challenged that Andrevet was seeking attorney's fees against the Saputo Law Firm PLLC, an LLC pursuant to Chapter 38 of the Texas Civil Practice and Remedies Code. It's simply not permissible. In response to that, Andrevet all of a sudden came to the realization that maybe it wasn't Saputo Law Firm that they were dealing with. All of a sudden, Paul Saputo became a proper party in their minds to sue. That's the person that they were really dealing with. we've got real uncertainty as to what they're claiming. And so in order to support their claims, we've challenged the evidence for which we hadn't seen, or the elements of the essential claims for which we hadn't seen supporting evidence. So we've, in our motion, challenged breach of contract regarding the Saputo law firm and Paul Saputo. With regard to the claim of the DTPA, excuse me, after the Saputo law firm filed DTPA claims, Androvet filed an amended petition that claimed that those DTPA claims were frivolous, and they're now seeking fees on those as well. That assertion of entitlement, that claim, has also been challenged by the summary judgment motion. Androvet has also claimed rights to relief under theories of quantum merit, alleging implied contracts in law as to both the Saputo law firm, PLLC, and Paul Saputo. And again, we've challenged that by the motion for summary judgment. And the last bit on there that we've challenged with regard to the motion for summary judgment is that assertion of the right for Androvet to collect legal fees against Saputo law firm, PLLC, pursuant to Chapter 38 of the Civil Practice and Remedies Code.
All right. Go ahead. I'm sorry, Mr. Bauer.
That's all right. Thank you. The non-movements seek to introduce exhibits A through I and now J and K into evidence. But I understand that the court's in possession of exhibits A through I. I'm happy to represent to the court that exhibit J is a 17-page document, the first 16 pages of which are identical to the first 16 pages of exhibit A. So it's essentially a series of declarations, and the last page contains a updated signature page from Mike Androvet, the declarant, with the date of, I believe, January 7th. But otherwise, the content on the previous 16 pages is, I believe, the non-movements have said they're identical. Exhibit K is a declaration from Ms. Bufkin, one of Androvet's attorneys, that I think attempts to support Exhibit J as a business record of their law firm and explains to justify that. Exhibit J, I don't think is probative as to the challenges in the motion. It just is used to justify J. We've objected to exhibits A and J. The objections to exhibit A start with, well, let me explain what exhibit A does. It's a declaration from Mike Androvet that attempts to, who's the president of Androvet, that attempts to outline a history among the parties according to him. And it also attempts to support exhibits B through I, the remaining substantive exhibits that the non-movements have attached, by claiming he's a custodian of business records. And so if exhibit A fails, B through I necessarily fail also. And by extension, if J is allowed as a supplement, J similarly attempts to support exhibits B through I. So the entirety of the evidence presented by the non-movements really hinges on the acceptance of one or both of exhibits A and J. The movements have objected to exhibit A because it didn't look right. When we examined the end of exhibit A, and I'm happy to pull it up for the court unless the court has their own copy open.
I have it open.
The important part to look on this exhibit is on pages 16 and 17 of it, and they're numbered at the bottom of that individual exhibit.
Hold on one moment, counsel. Okay, which page number for the exhibit?
16 and 17 on Exhibit A, Your Honor.
Okay, all
And
right.
what the court will see is there is not a page enumerated 17. The court will find that there are 2 page 16s. And on viewing this, it appeared to the movants that there's at least a question of whether the same document was signed. We've sought explanation for how 2 page 16s exist in a document. I don't know how it works in anyone else's documents, but footer page numbers are automatically populated in mine. And when I see 2 page 16s on a document, especially when the second page 16 appears that it's been integrated into this document by somebody else, it appears to be a photograph taken at a different location and then incorporated. It looks like a different document was signed on the 17th page. And so we raised a question about whether these are one and the same. But it certainly appears that at the time the 17th page with Mike Andrevet's signature was signed, it was attached to a document that only had 15 pages preceding it. Somehow the preceding pages grew. We don't know what part grew, and therefore we don't know that Mike Andrevet is testifying to any specific part of the preceding pages. That's what we sought an explanation for. The Exhibit J, as we've said, contains those same first 16 pages, and it now has a 17th page, properly marked page 17, and appears to bear a signature looking like Mike Andrevet's. That's for the non-movements to talk about, but it's untimely. And the issue with that isn't that a correction can't be made late. The issue is the information on the preceding 16 pages doesn't appear to have existed at the time the original response was filed. So I don't doubt that there was, a draft of this. The question is, what draft was Mike Andrevet presented with, and when did he sign it? How did it exist at the time it was signed? In terms of the typographical error, that doesn't seem like a typographical error. Unless we think that it's just they manually number pages, it looks like something else has happened, and that's why we questioned it. The other issue with Exhibit A is in the representations in paragraph 49, which is found on page 15 of Exhibit A, I believe talk about 90 pages of records. The other issue that the movements have brought up with this is in the response, there are 98 pages that follow. So which 90 pages of the 98 is Mike Andrevet authenticating? If we don't have an answer to it, then we've got 8 loose pages in those subsequent records, which we can't identify. So it calls into question each of the exhibits in B through I, and so the movements have objected. I don't think we saw any response to that from the non-movements. Additionally, Exhibits J and the similar content or identical content in A and J demonstrate on their face that the statements are hearsay. There's a lack of personal knowledge about them. They're conclusory statements. There's evidence in there where Mike Andrevet talks about Paul Saputo's eagerly and excitedly accepting services, and the evidence he uses to support that are the bills that Andrevet supposedly sent to, the Saputo and SLF, I call it, and Paul. Normally I'd refer to him by his last name, but since we've got a common one, Paul and SLF are how I'd prefer to do that. So with the authentication and the statements in there being conclusory, it's just not an affidavit that properly supports the additional exhibits. And without the additional support of those exhibits, there is no evidence presented before this court that supports its claims, and the motion must prevail. In terms of Exhibit C, these are supposed notes to which we've objected. I don't think there's any reference to who took these notes, when they were taken, or the basis of Mike Andrevet's knowledge about them. It's just a document that contains hearsay, and it doesn't really prove anything or lead to a genuine issue of material fact. Exhibit D should fail for a similar reason, and that's why it's been objected to. These are supposed texts. It doesn't really say who they're from or to whom they were delivered. And what that leaves us with is if A and J are out, the motion must prevail in its entirety. If A and J stay in, then I think some of the issues are simplified, and I'd be happy to get into those now. With regard to breach of contract as to SLF, the entity, we've challenged two essential elements of the plaintiff's breach of contract claim. Those are an actual breach by the Saputo law firm of a contract with Androvet. The second element that we've challenged is that Androvet was harmed by that actual breach. And so, in guiding the court, I think that's well illustrated in the motion, but also in the reply at paragraph 16. And what the movements have directed the court's attention to is a series of statements in the evidence attempted to be presented by the non-movements in Exhibit A, where they really talk about how the contract is with Paul Saputo individually, not with the Saputo law firm. So the problem we've got with this is the plaintiffs must show that there's a contract with the firm and that the firm's the one that broke it. If their allegation that Paul Saputo breached a contract does not mean that the Saputo law firm breached a contract. And so if we look at Exhibit A in paragraphs 20, 39, 45, and 48, we'll see that the assertions of breach are really against the natural human and not the entity. And without that essential element, the claim against the entity must fail. The harm element falls the same way. If the breach doesn't belong to the Saputo law firm, then Androvet cannot be harmed by it. And that's what our argument alleges, and that's what the non-movements response fails to address. And because of that, the breach of contract claim as to the Saputo law firm should be dismissed summarily. On the DTPA claims, the non-movements have asserted that the Saputo law firm's DTPA claims, which is the only party that made DTPA claims, were brought in bad faith for the purposes of harassment and that they're groundless. The plaintiffs haven't supported this in any way. I think they've fallen back on their pleadings, which aren't really evidence. That's not how you respond to a no evidence motion for summary judgment. We've challenged them on bad faith to produce evidence of malice or of discrimination somehow, and the evidence just isn't there. I'm not even sure that they've attempted to refer to any kind of exhibit with reference to that. The same goes for harassment. The court's not going to see any evidence of a purposeful harassment on the part of the Saputo law firm. That's the non-movement's burden. They have to show it, and the evidence just isn't there. On the groundlessness, it's similarly not there. They've got to look at the totality of the court needs to look at the totality of the facts. But I'm not sure that there's a single element of evidence there that does that. I know the non-movements talk about the procedural history of motions to compel and things like that. That's not evidence. And for that reason, the attempts for Androvet to recover attorney's fees from the Saputo law firm based on their claims that the Saputo law firm's pleadings constitute a DTPA violation must fail. No evidence means, those claims for relief for attorney's fees by the plaintiffs need to go. Next, we move on to a quantum merit claim against Paul Saputo individually. Androvet's evidence, and we're in paragraph 32 of the reply. Androvet's evidence, especially found in exhibits A and J, the declaration of Mike Androvet, affirmatively represent that there is a definitive agreement between the parties. If that's the case, it negates the idea that an implied contract in law can exist. So the court would have to allow contradictory testimony to permit the quantum merit claim against Paul Saputo to survive when the plaintiffs are claiming an actual contract exists. Again, it doesn't appear that the respondents or the non-movants have really raised evidence that supports the idea that no contract exists. And that's essential here. They cannot have quantum merit with the existence of a contract. As for Chapter 38 on the attorney's fees, I haven't seen any evidence. I haven't seen any documentation suggesting that the Saputo Law Firm PLLC is not in fact a Texas LLC, or anything else that would allow a statute that does not allow for recoveries against an LLC to permit the recovery of attorney's fees against such an LLC. Since there's no evidence, that claim needs to go. I think there's not a strong need to address the other challenged elements because those really hinge on exhibits A and J. If A and J stay, I think there may be a scintilla of evidence as to the specific claims that I haven't brought up with the court just now. And so I'm happy to be cognizant of the court's time with regard to that. In terms of the idea that an adequate time for discovery has passed, the non-movants have brought their own motion alleging that an adequate time for discovery is passed. The discovery period as defined by the Texas Rules of Civil Procedure has closed. I don't think that's in real dispute. So with that, I'm happy to hear from the court or the other side and would appreciate reserving some time to respond to whatever they'd like to present.
All right, thank you. Ms. Buffkin, will you be arguing or Mr. Cook?
I'll be arguing, Your Honor.
Okay, the court will hear from you at this time.
All right, thank you. Well, Your Honor, today the plaintiff's burden as the respondent to this no evidence MSJ is that we have to present that there's more than a scintilla of evidence that there's an issue of material fact at issue against one of the elements presented in the no evidence MSJ. I mean, and what we filed in response to his no evidence MSJ is that our declaration alone shows all the elements. It shows more than a scintilla of evidence. I think burden has been met. And the reason why our response is so long, it's so many pages, I know it's a lot of reading, forgive me, but we had to put everything on the table and show, look what our client provided, Mr. Saputo and his law firm, the benefits that they've enjoyed, that after services that our client offered Saputo and his law firm, and that they both accepted and are using a benefit enjoyed, and they're still using a benefit enjoyed. As from our exhibits where, there are interviews that we arranged for Mr. Saputo, they're still displayed on Saputo Law Firm PLC's website to this day, as we attached in one of our exhibits responding to the court. As to the issues with Mr. Bowles' pointed, or so-called issues regarding our declaration, that was some technical error. We didn't realize that the last page didn't autocorrect as it should have. We don't know why, it just didn't. But what we submitted to the court was what Mr. Mike Androvet saw and he signed off on. And when we didn't even realize there was that technical error until Mr. Bowers' reply to our response pointed it out. So to satisfy him and also to make sure that everything was in order, we corrected that technical error, which is why we filed the supplemental response and Exhibit J. And under Texas law, we're allowed to correct a mere technical error. And I don't think our entire declaration should be invalidated just because of a mere technical error, which we corrected. Substantially, it complies with Texas law. Otherwise, a typo shouldn't invalidate the whole thing. And also, Mr. Bowles pointed out that we referred to 90 pages of exhibits. and he's saying there's 98. Well, those 98 pages, they include exhibits A, B, C, D, E, F, G, H, I. That's 8 pages. 98 minus 8 is 90. So we didn't include, when we counted the pages up that were attached, we didn't include like A, B, C, D, those pages. So that's why we say 90 and not 98. That's a standard practice that we do at our firm whenever we file these kind of motions. All right. And furthermore, in response to Mr. Ballas says there's no evidence that we presented showing any bad faith on Saputo Law Firm LLC's part for filing the counterclaims, the DTPA violation counterclaims. Well, not only has there no evidence been presented by the other side following up those claims, like we have yet to see anything showing that, one, there's any fraud or concealment or misrepresentations on our part. And also our exhibits we submitted our response show all of our communications with Paul Saputo and his firm. And they show that everything we represented and everything we told them what we were going to do, or my client was going to do, we did. And Paul Saputo was very, very pleased with them, as you can see throughout our communications, particularly our text messages that plaintiff Androvit's firm exchanged to and from Paul Saputo throughout the entirety of their business transactions. And furthermore, the bad faith or harassment elements of proving groundlessness, those are questions of fact that should be left up to a jury to decide. And let's see.
Ms. Beth, can you, you can go ahead and finish your statement. I don't want you to lose your train of thought, but I do have a question afterwards that I'd like for you all to address, and that is the quantum merit claim and the breach of contract claim.
Yes. So the quantum merit claim is a pleading. We pleaded in the alternative in our pleadings, which we're allowed to do under law. It's not we're not trying to do two things that contradict each other at the same time. They're alternative pleadings. If you don't find for one, then consider the other, which is what we pled. And at the moment, that's all I have right now.
Okay.
Your Honor.
All right.
I think the evidence speaks for itself. That's pretty much. I mean, it's all there. I mean, that's.
All right, Mr. Bauer, a brief response to the argument.
Please, Your Honor. In response to the arguments of Ms. Bufkin, the first issue I'd like to point out is focusing the court's attention on the specific elements of the claims that we're talking about. Ms. Bufkin talked about services allegedly performed by Androvet. Services do not equal contract. We've asked for specific elements substantiating the existence of contracts. Services are not that. We need material terms. We've asked for those. So the one does not carry over to the other. The next issue I take with the argument is Exhibit B. The court will find throughout Androvet's response that Exhibit B is continually used to justify the defendant's supposed acceptance of the services. What the court will see when looking at Exhibit B is that those are invoices supposedly drafted by Androvet. I have no idea why they think that sending someone an invoice means that that person has accepted and liked your services, especially when they're alleging at the same time that the people that received that invoice didn't pay it. It's just asking for the court to make a logical leap that isn't there. That doesn't lead to the substantive issue of a genuine issue of material fact. That's them making an inference on their own. I can't say sending a bill to one of my clients means they're happy to receive it and they love the services. We certainly hope that's the case, but that is not a reasonable inference that the court's able to make here, even with the lax standard under a 166 AI motion. In terms of the justification of Androvet's essentially DTPA counterclaim seeking relief under the DTPA for the attorney's fees, the evidence it sounds like they're presenting to the court is that correspondence supposedly occurring before the existence of the lawsuit explains that subsequent actions, filings made in this court, the Saputo Law Firm's pleadings made years later are somehow bad faith. The timeline just doesn't add up. There is not a reasonable inference that links those two together. Past action explaining future conduct years later, it does not make sense. As to the discussion of the contract versus the quantum merit, Ms. Bufkin's right that they're allowed to plead in the alternative. The problem they've got here is that they've affirmatively negated that quantum merit claim. If Mike Andrevet's affidavit is taken as truth, which it purports to be, then that quantum merit claim must go. They are not allowed to plead necessarily contradictory pleadings when they've essentially committed to one. Both things cannot be true. And I'll defer to the court for questions if it has any.
All right, thank you. Ms. Bufkin, I did want you to respond to the assertion that counsel raised with respect to Chapter 38 attorney's fees being asserted against the entity and whether or not the statute provides for that.
Yes, Your Honor. Well, in the no evidence MSJ, the defendants say we can't get attorney's fees under what's it called? Chapter 38.
Chapter 38.
However, the no evidence MSJ didn't respond at all to the attorney's fees requested under Texas Business and Commerce Code, Section 17.50, subsection C, which is related to the ground that the DTBA counterclaims were groundless. That wasn't addressed at all. So that's still an issue that needs to be addressed. If not here, then a trier of fact with a jury trial. And also, sorry, any other questions, Your Honor?
No, I just want to make sure that I heard a response from you all with respect to that. But you can respond to Mr. Bauer, and then I'll probably have some final words and ask you about pertinent orders being uploaded with respect to the motions that are before the court today.
Okay. Well, as to Mr. Bowles is trying to say that it's either like we're pleading breach of contract and quantum merit, as if you can't plead them in the alternative, which we have. And honestly, I was a little confused on where he was going with that, because it's obviously we're pleading as an alternative claims rather than, oh, it's all or nothing. And also we don't have a written contract, so we needed to plead quantum merit as an alternative claim in case the trier of fact doesn't find that we have a contract. I mean, we just had to do that. And furthermore, his issue with the invoices that our client sent to Paul Saputo actually confirmed that our communication, my client's communications with the Saputo, the law firm, and Paul Saputo, and also they showed that Paul Saputo accepted our services. Not only accepted them, he benefited from them. So there was a showing that there was an acceptance, and also throughout the entire time that our client provided services to him, we heard there was no sign that Mr. Saputo was, dissatisfied, displeased, or felt like there was a misrepresentation on our client's part. I mean, there's nothing. There's nothing out there to show that. And so far, we haven't seen anything that shows that that's been provided from the other side. So, I mean, again, everything we presented before the court in our response shows that not only was there some sort of offer, acceptance, meeting of the minds, delivery, in the alternative, at least we provided services. The defendants have accepted and used those services to their benefit, and still to this day benefit and enjoy those services. I mean, the interviews we arranged with Mr. Saputo are all over the law firm's, law firm's website, like to this day. So, I mean, and the fact that they're basically saying they don't owe our client funds. I mean, and we haven't suffered any damages because we're still owed, my clients owed at least $5,000 for the service that they provided for them. They're still have never been paid for that. I mean, honestly, it's a little mind-boggling to me that they're taking this position.
All right, Mr. Bauer, I'll give you final words, but I do have a question for you, and that is whether or not a scintilla of evidence has been raised with respect to any of the claims that are before the court. Obviously, you need that. They need that to defeat the motion for summary judgment. So I'd like for you to address that and any final words.
Okay. So scintilla and my response, right, Your Honor?
Yes.
Okay. In terms of the response, with regard to Chapter 38 versus Business and Commerce Code 17.50, the court will notice that we didn't attempt to defeat the fee entitlement to Business and Commerce Code 17.50. We challenged one of their specified claims to attorney's fees, and we expect them to segregate those fees. And I expect that the ones they're attempting to collect for breach of contract against an entity for which they cannot collect breach of contract fees needs to be defeated. And in the event that they were able to prevail on the breach of contract claim, they shouldn't be able to charge my LLC client attorney's fees for breach of contract time for which attorney's fees aren't required. So the 1750 arguments are red herring by the non-movements. That's not what we're talking about. The DTPA claims that we've challenged here are the underlying facts, not the result. With regard to Chapter 38, we've challenged the outcome with regard to whether fees are acceptable. In terms of the scintilla, I tried to indicate to the court that my presentation of evidence today was limited, dependent on the acceptance of Exhibits A and J. And so the court will notice that in my detailed presentation of evidence, I limited the breach of contract argument to the Saputo law firm. I did not talk about breach of contract with regard to Paul Saputo, because if A and J are accepted, which we think they shouldn't be, those documents may contain something that could allow the court to find a scintilla of evidence with regard to Paul Saputo on breach. With regard to the DTPA, my argument stands. The DTPA challenge, the DTPA claims were only filed by Mr. Saputo, and therefore, excuse me, I got that wrong. The DTPA claims were only filed by the Saputo law firm. And so those only apply to that entity. The same applies to the plaintiffs, Andrevet, seeking relief with regard to that specific claim of the Saputo law firm. So on those, we stand by everything regardless of the acceptance of A and J. With regard to Quantum Merowit, the court will note that in my detailed enumeration, I just talked about Quantum Merowit as to Paul Saputo. We did not discuss the Saputo law firm and Quantum Merowit. And with regard to attorney's fees under Chapter 38, I stand by my presentation. I don't think they have a scintilla under any acceptance of evidence. Is that outline for the court exactly what we've gone through?
Yes, it does. It does. Mrs. Bufkin, did you need to respond to anything that the court has heard?
Honestly, I think the evidence that we presented in our response speaks volumes about what our client has done for this Paul Saputo and his law firm. So.
All right, let me make sure that I have orders with respect. I can tell you that when I have this case pulled up, anything that was filed this morning or late last night, it may be in the clerk's queue that needs to be pulled down. It's not showing up on my particular screen, if that makes sense to you all, but I can get it. I do need orders with respect to the motions that are before the court today. I do see hold on a second. I see an order denying the defendant's no evidence motion for summary judgment. I don't know if I have an order in opposition to that. So I just want to make sure that I have the appropriate orders that I need in order to rule on what's before the court today. I don't know, Mr. Bauer, since there are some objections made to the evidence, if there's a separate order or if that is included in the order that has been submitted to the court.
If you're asking for a response, Your Honor, I believe the proposed order that we have submitted to the court, and I do think it should be on file, would suggest that in our form order, it says the objections which, weren't sustained. So
Okay.
I think it addresses that. If the court would seek something more specific, I'm happy to do
No,
that. But
it's fine if it's there. I just, I am, this is my first week here, so I go to use something and find out I can't use it. I have to call IT. So I'm just trying to keep the cases moving despite my technical difficulties that I'm having. And so if your order's there, I can find it. I can get it. I just want to make sure I have what is needed in order to rule. So you all can expect a ruling from this court by the close of business today. The way that you will know how I ruled is I will send you a copy of the order that I do enter via email. And that is how you will know that I ruled on it. Okay.
thank you, Your Honor.
All right. Is there anything? So if you all would just do me a favor and check the filings with the court to make sure, okay, our order is there. And if you notice it's not there, then go ahead and upload that so I have what I need in order to make a ruling for you guys.
Thank you, Your Honor. Thank
All
you,
right.
Judge.
That sounds good. Take
Welcome
care
to the
and
bench.
stay safe.
Take
Thank
care.
you. Take care. Bye-bye.
Bye.